Hi, everybody. Welcome back to the 10th of an Hour with Griffin Bridgers. For today's episode, episode 27, before I get into the subject matter, the great irony is that I was looking at a way to present this maybe with the ongoing slogan under this series about making estate planning fun. And then the first episode out of the gate with that theme is probably the least fun subject we can cover in estate planning, and it is the effect of divorce on estate planning. So nobody likes to really think about that. So we're going to approach this, from a practical client perspective, but also from the perspective of, are you a wealth advisor or an attorney who's dealing with a client who is going through a divorce, and maybe you're not as well educated on estate planning issues. But as always, the advice in this presentation is not intended to serve as legal or tax advice. So if you're a client thinking of implementing these strategies, you should consult with an attorney or tax advisor. So jumping into the problem, most married couples create an estate plan while they're married where they include each other in their documents, and also potentially as beneficiaries on things like life insurance and retirement plans. Not only that, but they're also named as fiduciaries, so they'll play roles like personal representative under the will or agent under powers of attorney, trustees under trusts. So once you're divorced, the question is, what happens if you never get around to updating these documents? Are they still going to be effective? And could this result in a divorced spouse getting a piece of your estate and maybe even having the authority to act on your behalf, which would be a bad outcome? And also, what if there's a common law marriage that could be argued in this case as well? If you were never truly married, could a spouse come and claim that they had an interest in your estate due to a common law marriage? Now, the question is really dependent on which state you are in. Now, depending on the state, once a divorce is final in that the court issues a decree of divorce or a decree of annulment, then a divorced spouse is usually just treated as being predeceased under one or more of the following documents. That could include a will, it could include a revocable trust. Sometimes it includes an irrevocable trust, less often than yes, but also beneficiary designations. You can also have a spouse's interest terminated as well. But the overall effect of that treatment as having predeceased is that the spouse will just have their interest terminated in these types of agreements, and also will have their fiduciary designation terminated by operation of the agreement. And whoever the successor beneficiary or fiduciary might have been will be the person who gets the asset or fills the fiduciary role. But the big issue here is that these don't happen until the divorce is final, and even more, once the divorce is final, it may not affect all of these documents. So during the pendency of a divorce, or if there's just a legal separation ordered by a court, the problem is that none of those actually affect the estate planning documents unless the documents themselves have terms that say, upon filing a petition for divorce or termination of marriage, a spouse's interest will be terminated. We'll talk about that in a minute, but in the meantime, it can be a good idea once you start the divorce process to update your estate planning documents, but in doing so, it's important to also beware of what's known as the automatic stay, which prevents transfers or changes to asset ownership once a divorce is commenced. And in some states, it's been found that beneficiary designation changes could violate this automatic stay. And what hasn't been settled is really the question of, does a change to estate planning documents also violate that automatic stay? Sometimes yes, sometimes no, but it's important to kind of know what that means in your state and what that effect of the automatic stay has on your actual estate planning documents themselves. Either way, I think it's safe to at least update your documents to change the fiduciary designations so that, for example, you don't have a spouse as trustee of a trust having the ability to raid those assets, or a spouse as an agent under a power of attorney. So if you become disabled or incompetent, then they could all of a sudden, use that power of attorney to divert your assets, essentially. Now, irrevocable trusts are their own separate beast. A lot of states don't terminate a spouse's interest in an irrevocable trust. So, as part of the divorce process, it may be a good idea to negotiate as part of the divorce settlement that a spouse might agree to a modification of the trust or a decanting or a disclaimer or something through settlement. And sometimes there can be gift tax issues relating to those, but in most cases, a transfer pursuant to a divorce decree or a divorce settlement will not be subject to gift tax. So that's not necessarily a concern there, but in the best case, a good drafting is that up front in the irrevocable trust, you can say that the spouse's interest in the trust is contingent on the marriage continuing. But the problem is that this can be hard to sell to a married couple as clients. So sometimes you have to get around that objection on the back end if there is an actual divorce. Now, there can also be a marital agreement in place, and we won't dive into these in great detail, but these are also commonly known as prenuptial agreements or sometimes postnuptial agreements. These can affect the estate plan, especially if a spouse, as part of the divorce, successfully challenges the prenup, because often a prenup will waive certain guaranteed rights that a spouse has to a deceased spouse's estate. These include things like the elective share, where a spouse could get up to 50% of the deceased spouse's assets. It could also include the intestate share, which is what a spouse gets when there is no will or when a spouse appears to be omitted from an estate plan. And also there are certain state law allowances that may be permitted as well that are often waived but could be taken by a spouse if the prenup is overturned. So it's important to make sure that the prenup or marital agreement meets all the requirements to be enforceable, things like full and fair disclosure of assets and income to each other, and also that it's signed not under duress, and that each spouse has the right to independent legal representation or waives this right as part of the signature and review process. So divorce is never a fun subject, but those are some of the high points to consider if you have clients who are considering divorce and have an estate plan which provides for each other or even a marital agreement in place itself. So, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you again for listening to this episode of the 10th of an Hour, and I look forward to seeing you in the next one.